Hi, my name is Mohammad Abdul Majid. I'm here to explain the case the Bell Group Limited versus the Westpac Corporation 2008. It is a noticeable fact that liquidation and breaching is the most common issue arising in company sector. Most companies, owners and employees are consistently accused of breaching. Breaching usually takes place for fiscal benefits. The impact of this case will lead to the development of Australia's corporation law. In 2009, August 19th, Justice Hassler on this case gave his decision. The case was commenced for the fact of the application from the banking sector for the liquidation. The liquidation usually takes place when the company wants to wind up so that they can have an impact on their losses. In this case, the Westpac corporation gave a clarity that they were facing financial losses. That is the reason they plan to wind up their business and do liquidation. In this concern of liquidation, the liquidators are assigned in such a way that justification revision of assets are done. However, the banking authorities have exclaimed that the process of liquidation has not been done properly. To claim or to oppose this decision, the Bell Limited said that because they were going into the losses, they decided to wind up the company and do liquidation. However, Justice Owen gave panel of liquidators and asked them to pay the loss to the Bell Limited, of which is accumulated for $1.5 billion along with the interest. But the liquidators opposed, saying they cannot. It will not be an easy task for them to repay the loan of 1.5 billion, which is a huge amount. However, it was a very difficult task for the judges to ascertain who's right and who's wrong, because the liquidators were trying their best to defend themselves. On the other hand, the banking sectors were giving explanation that to refrain themselves from paying all the losses to the liquidators. This contrast, the bank decided to know whether breaching has been actually done or not. This measure helped them to know that who's breaching the law or not. So,
And there you go.
the identification of breach helped the judges to know who's at fault and who was breaching the process of liquidation. The next part would be explained by group member Manpreet.
My name is Manpreet and I am going to discuss about the breach of the duties of the directors. The breach of the duties of the director, it is clearly seen that in the case of commercial sector, that whenever the members of the company are going to share their personal information with the outsiders for their own use, whereas we know that the breach of the duty is not is a different fact, and whereas we know that the breach of duty is a different fact and is a different fact. In the case of Westbank and Bell Group, the issue regarding breach of the duty arisen when the Bell Group did plan to restructure its loan with unsecured bank creditors in return for securities and guarantees. So whereas when the bank is decided to recover the funds from the securities and guarantees, the liquidators are going to sue that the Bell was evidently insolvent. So in this way, guarantees and collectors were accused of breach of directors of duties. Thanks.
I'm going to talk about the different court decisions which the judges have taken for the case. The court reviewed the case and they have investigated the various authorities. The judges at the High Court has taken into consideration various laws, and then they came to the conclusion of this case. The primary laws that are prevailing in this case are Section 479 subsection 3 and Section 477 subsection 2b of the Corporations Act 2001. These are the two acts which have helped the court to come into the conclusion for the case. Section 479, subsection 3 of the Corporation Act talks about the powers and the controls of the liquidators. It allows the liquidators to apply to a court for the direction in the relation how they are winding up their company. The functions of the liquidators, actions for direction under this section is to give the liquidator the advice as to the proper course of action for him or her when they are undergoing under the liquidation. And when we talk about section 477, subsection 2b of the Corporations Act, it prohibits the company to enter into the long-term contracts. Now, the court held that the main liquidator is acting accurately, justifiably, and properly, that is rationally, in opposing the application of banks, which is to suspect the fiscal orders which were made by Justin Owen. The court also held that it was appropriate, having regarding the primary terms of the proposed claims, that the liquidation must be granted approval under section 477 subsection 2b of the Corporation Act to provide charge in favor of the bank. And you know what happened? The banks were charged with $1.5 billion. And that's it. That was the decision of the...
Hello everyone. Now I'm going to present the principles of the case. The primary of the court to deny or grant the approval of proposal to the liquidator is not preferable. Additionally, court also asserted that it is not authorized to develop an alternative proposal. The court also decided that its task is not based on the reconsideration of all issues which are raised by the liquidator during proceeding of the case. The court planned that its main task is to examine and review the proposal of liquidator while paying due attention the commercial judgment of liquidator after collecting information of all situation of the case. The court also ensured that its main purpose is to satisfy itself by certifying that it has not made any error. In making the final decisions for the company, the court also assessed that its approval should not consider as an endorsement any proposed agreement. Based on all these principles and the requirement to protect the funds paid under the fiscal orders pending resolution of the petition proceeding, that court held that the main liquidator is acting rationally and justifiably in opposing the application of the bank in order to suspect the fiscal orders which were made by Justin Owen. Thank you.
This is Shiva. I'm here to talk about the decision took by the court and how it is going to affect the Australian corporation law. After looking at the case, the breach of duties and the court decision, it can be easily said that the decision can put a heavy impact on the Australian corporation law, and as the government has the right to change or modify the rules of the corporation law, which helps them to reduce the time taking to give a resolution for cases of the similar kind, for example, like the Bell Group and the Westpac banking solutions. It could also be considered as a precedent as the decision is given by the higher court and it is to be followed by the following courts. And the decision could also have a significant impact of the operations of Australian companies, as the management of the company ensured that the breach of duty is never involved at any time in the process of liquidation. So the decision took by Mr. Justice Owen in 2014 with the respective case could be applied to the both syndicated and non-syndicated loans where a group of Australian companies has been involved in the process of liquidation. And the decision could also, the legal findings of this case can force the duties of the directors and banks who fall in this kind of situation in future, and this helps them to reduce the time in giving a resolution for the case. The case also exposes that a bank that obtains additional security to the genuine risk, that security will be declared invalid and the income of the realization of security will be paid to the company by the creditors. In this case, it can be easily said that the government, that Mr. Justice Owen has took a decision in this case and gave a resolution. So that resolution is considered as a precedent and be followed by the following courts and judges who who gets a chance to deal with this kind of similar issues